Good morning, everyone. So we are now going to start the session, which deals with the rules and regulations of managing apartment associations and societies. We have with us Mr. Sudhir Pillai, who is an activist, and Vidya, of course, Vidya Gogi, all of you know, she's part of BAF, and Mr. Ravi Bhadwaj, who is the head ERP at MyGate. I would now request Mr. Sudhir Pillai to introduce himself.
Good morning, everyone. Firstly, let me thank BA for this forum where we can air our views and listen to others. I think it's a great initiative and this needs to be done. I was introduced as an activist, but I'm just a homeowner, a home buyer. But having said that, what I realized is when a lay person puts down a substantial part of his savings and buys an apartment, he has to contend with what are a lot of laws, a lot of regulations. And with the coming into force of the Regulatory Act, the Real Estate Regulatory Act, there are a lot more that is involved. So how did I get into this? Let me quickly say this. When I bought my apartment and when I slowly understood what was happening around me, I realized that there are a lot of differing opinions, which are put forth, one by the developer, second by the home buyers themselves, and third by the associations who are expected to manage these properties. That's when I decided to look at the laws and the rules and try and figure out who's right, what's it all about. That's when I got exposed to what is actually a very unregulated space. As my developer, senior management official of my developer mentioned to me, he says, when I asked him, don't you follow the rules, the laws? He said, no, we follow industry practices. So that is something we need to debate about. Are these industry practices okay? Are laws binding on us? What about enforcement? Because these all have a lot of significance. And that's how I got involved in the subject. Now I got into it in depth. And what I realized is it has great significance for each one of us, not just who are home buyers, but developers, association, and various else. And hopefully through this session, we can discuss and debate some of this. Thank you very much.
Yeah. Can I now request Mr. Ravi to introduce himself?
Hello, everyone. First of all, thanks, Vidya ji, for inviting us. And so my name is Ravi Bhadwaj, and I am an engineer and a management professional with education background with almost 13 plus years of experience. I am an ex-entrepreneur also. I ran my own business, and for last 1.5 years, I'm heading the ERP business of MyGate. We have almost 5,000 societies across 20 different locations in the country. And they range from somewhere around 100 units on the lower end of the spectrum to the almost 2,500 unit apartment units on the higher side. We are present in all large, like all metros, your usual suspects like Delhi, NCR, Bangalore, obviously, which is our main hub, Bombay, Pune, Hyderabad, so on and so forth. And we are actually, with the advent of with what happened in 2020 with COVID and COVID situation, we are seeing a higher penetration in tier 2 and tier 3 societies, with the like societies in cities like Ajmer, Jaipur, Coimbatore, right? We are seeing that people are adopting, and that's part of the macro trend that we are seeing, that the penetration of technology has actually skyrocketed. So coming to MyGate ERP, we have different modules we facilitate, which basically help RWA collect payments, communicate with their residents, and we are innovating on like even how this we become the platform of choice for RWAs as well as for residents and other stakeholders like vendors, non-members of the society.
Okay, thank you, Ravi. Of course, we all know who Vidya is, but I'd like her to say a few words about herself so that everybody here gets to know her better. Yes,
Yeah.
please,
So
Vidya.
by qualification, I'm also an engineer and a management graduate. I have worked in corporates in Mumbai as well as Bangalore for about 14 years before I, before I had to take a break for family reasons. But since last 6-7 years, I have now gotten engaged in a lot of RWA as well as community activities. And I'm slowly realizing that while during our work days and all, we stayed in apartments and we were more worried and bothered only about our homes, our individual apartment. There is a lot more that happens to ensure that the entire community stays compliant, and a lot of work which is being done behind the scenes by volunteer, the volunteer members of the community. And it is a huge task. It is a facilities management task, which is being left to be managed by many homeowners without really being aware of various compliances and things that are required to be done in a professional way. So this, along with a couple of incidents that happened with respect to my community, wherein we were there was allegations of encroachment. There were various notices, retrospective laws being enforced on apartments. All these issues sort of, put me in the forefront, looking for solutions. Wherein I thought an organization like BAF, wherein we all collectively come together, can discuss and can come together and discuss about all these issues and see how we can take it forward, so that living in apartment communities, while on an individual basis has been safe and secure, but a community as a whole, is there some way that we can really work together to be more compliant, contributing positively to the city as a whole, and at the same time, a lot of things that we can think of beyond our apartments as well, in terms of contributing to the environment and sustainability and all these aspects. So that's how, since last few years, I've been a part of BAF, driving a lot of such initiatives. And Suhail, we would request you
Thank
to
you, Vidya.
also
Yes.
introduce yourself here.
Yes. Yes, thank you, Vidya. So I'm a legal professional, and I'm a partner of a law firm called Trial Base, and I'm also the chief legal consultant for a consultancy firm called RERA Consultants LLP. I predominantly practice on property laws. Of course, that's how I know Vidya also, that during the course of my practice and my activities that I've come across BAF also. And I'm actively working in the real estate sector. I could say that 70% of my practice involves real estate. So I come across various issues relating to real estate, not just the property issues, but also the compliance issues and regarding rules and regulations. And of course, the Real Estate Regulation and Development Act, which is a new act which is which has come into force and which has kind of changed the entire gamut of activities when it comes to real estate and the construction, the promotion, and how things are handled under real estate. So with this, I think we can start. First, Mr. Sudhir, I would like to ask you, as a consumer and as a person who is now, by having purchased an apartment, what are the challenges that you have faced till now with your purchase, and how are you seeking to address these issues when it comes to rules and regulations governing apartments?
Yes, I think that's a very interesting question you asked, because what I've realized is that there are two sides to this coin when you purchase an apartment. One is the side that involves the builder, commonly called the builder, but more I think legally in the Real Estate Act and even the Karnataka Ownership Flats Act, the person called the promoter. So there are you first engage with the promoter. I'll use the term promoter rather than the builder. And the promoter has certain responsibilities and obligations to the buyer, and the buyer too has some obligations to the promoter. Now, that is the first part that needs to be looked at. How compliant are they? Vidya has used the word compliant at least on 2 occasions. So the first compliance that we need to talk about is the compliance between the buyer and the promoter, for which there are 2 regulatory acts. That is, not just the Real Estate Regulatory Act 2016, but you also have the Karnataka Ownership Flats Act of 1972. The second act which I spoken about is often ignored by everyone, not just by the developer for his own good reasons, but buyers because of their ignorance. That's one side of the coin. The other side of the coin is that this regulatory act envisages a transition to the buyer of the apartment, that is ownership transfer to the buyer, and also that of the common areas to the association that needs to be set up so that the co-owned spaces can be managed. So there are two sides, and both have got unique laws in my view, and they need to be looked at. So when Vidyaji says that one of the things she takes up is how to ensure that the community stays compliant, I would submit, and we can discuss this as to what is that they need to be compliant with. I would propose that this compliance must be with the bylaws of an association. Then the question comes, who drafts the bylaws? Often you will see the bylaws have been drafted by the developer as part of the responsibilities under the Regulatory Act, but that's never followed. And an association forms up, some volunteers come together, well-meaning people, they draw up their own guidelines and seek compliance. In between these two, there is a gap. And in my view, this gap needs to be bridged. One more thing I'll quickly make a point is that when I looked at this from a home buyer's point of view, when you talk about common areas, there is a necessity under law for conveyance of the common areas. Vidyaji and BF, they invited me to attend an international seminar here in Bangalore sometime back. And what we realized in that international seminar was that besides facility management, world over, when our complexes become big and more modern, though world over, there is a requirement for not just facility managers, but there are also community managers and estate managers. While communities may still manage themselves quite well, this business of estate management, especially the management of land, is an extremely gray area which we need to discuss and talk about, because to me, that it is central to proper regulatory compliances and enforcement. That's what I would say is my experience so far as a home buyer.
Okay, thank you, Mrs. Speer. So we all know that when it comes to apartments, what governs apartments is the Karnataka Apartment Ownership Act and COFA during the period of construction. Though we adopted the Karnataka Apartment Ownership Act from the Maharashtra model in 1972, and we know that there have been absolutely no amendments as such to KOA or COFA. While the MOFA and the MOA have undergone several amendments to meet the requirements of the present day requirements. So there is a kind of a vacuum or a gap there between the statutes and the implementation. How do we implement the statutes that we are following? The one of the most important things I would like to point out is the when you see the definition of common areas under the Real Estate Regulation Act and the KOA, it includes the entire land and all the other facilities. Of course, there are one or two things with regard to parking, where open car park is left out in the common definition of common areas in RERA. However, in KOA, all the car parks are also included. So other than this, and now under RERA, the entire common area, which is the entire land, is required to be transferred to the Association of Allottees. But however, we don't know how that transfer can be accomplished, because the Stamp Act needs to be amended and a different nomenclature of a document needs to be brought in by the Stamps and Registration Department. This is not just the case in Karnataka. I think the same issue is being faced by Telangana, AP, Kerala, and other states. I think except Maharashtra, which follows the cooperative model, all other states face this issue. Because the next question is, who pays the stamp duty? Because when you take a document for a transfer of the common areas, which is the entire land, the sub-registrar would obviously assess the land for the entire value and then demand for stamp duty to be paid on the entire thing. Of course, unless there is a exemption on that, that cannot be accomplished. So there is this gap between the statutes and the implementation. Perhaps over a period of time, when all these things come together, we'll see that happening. Now, I would like to ask Mr. Ravi, what is the approach that MyGate takes to make sure that apartment complexes remain compliant with the prevailing laws as a technology platform?
Yeah. So, so like as you mentioned that in the Maharashtra, they are following cooperative model, and they are a little bit ahead of the curve, pan India. So what we recommend them is it's easier to recommend when there are best practices, when there is a clarity on the regulation side, right? So in the in the state of Maharashtra, we have like the regulations in our system which we can offer to them, right? That's the first step we take. Second is we have accountants and people in the role of, who have been past RWA. So we organize our seminars or webinars nowadays, so that the knowledge sharing can happen between them, right? Whereas in other states, like as I was talking before, there is a lot of gray area, especially around elections and the other, like the taxation part. The it is harder to recommend best practices, and unfortunately in those cases what happens is we end up telling that what you can do with the platform, but it is better to consult somebody who is knowledgeable in this thing, right? And so what we are doing for Maharashtra, like organizing webinars, we are bringing it for specific other states as well. So like in the NCR, the rules are a little bit different than compared to what it is in Karnataka. And so go, and on top of that, these regulations are all themselves are coming under, what do you say, stress, because of need for taking a lot of things online, but the regulations prohibit, or at least do not allow people to take the business online. So like as Pillai sir mentioned that they wanted to conduct meeting online, but they were denied by the authorities to take it, right? However, they put a stay, but that's not an apt solution, right? So obviously in this scenario where you are lacking the knowledge, or not knowledge but the clarity in the of the regulation, it is harder to recommend best practices to people. In that case, we recommend people to, or we recommend RWS to consult experts, and if they are short on that, we facilitate that point. Like we know experts, and we recommend that these experts can be consulted.
Okay, can you just add on to that? What are the steps that you have taken to make sure that the apartment complexes remaining compliant with the laws? Anything specifically that you have done?
So specifically, like we provide them the what are the bylaws which are, I mean, which are followed in other societies. So this usually comes up in societies which are going into exist, or RWS which are going into existence right away, right? So like there is a handover happening from builder to RWA. They need certain sets of guidelines which are already being used somewhere else, which they can use as their own guardrails, and then they can build on top of it. They can slice and dice it as, or amend it as the way as they feel need, right? And usually what happens is like society, as long as the society in the ballpark area of number of units, they can replicate it, the constitution of a similar society for their own need, use it as a foundation, and then change it as they feel required, right? So like suppose there is a 1,000-unit society in Whitefield, and there is another 1,000-unit society coming in HSR where the handover is happening. The Whitefield society has been in existence. We can help the society take with their bylaws. Obviously, the information has been redacted from the before we pass on, and that can be used as a foundation for the new society.
Okay, can I just interrupt Mr. Sohail with your permission?
Yes, please.
Yeah, Mr. Ravi, since he represents MyGate, let me just put across a few things for MyGate's consideration as far as compliance of laws is concerned. When people buy into a flat, one of the things that they do finally get is ownership. And central to that ownership is an easement right. Now, in practice, we've seen many people using software tools like MyGate. They get together as a community, as a group, and then they will put out some extraordinary rules through MyGate, denying easement and such other things. So if you ask me here, there's a violation of the law taking place. The owner has an ownership, has a right of easement, whereas a tool like yours, so I would submit to MyGate, and that it's not just the buyer and the developer who have to be compliant with the laws that exist on the subject, but it is even for MyGate and such other ERP solutions to look at the laws. For example, when you talk about parking, Mr. Sohail Ahmed spoke about parking. There's a Supreme Court judgment on this, which is clarified as to where we stand as regards parking. But then using software tools, there can be impositions. I'm aware currently of an approach made to a certain DCP here in the city of Bangalore against such practices being enforced, where easement rights are being denied, where parking laws are not being followed. So there is a law involved, and I think it may be well worth a while also to look at these in a deeper aspect and get compliant. This is my submission.
Sure, sir.
Okay. I'll of course,
point taken, sir.
I'll take this up with Mr. Ravi as we go further. Vidya,
Can I just add on to a few things? I didn't realize I was on mute.
Okay.
Just to say something, so far as the solutions that MyGate provides, while they need to be aware of the laws on a broader perspective so that they can have a shell of their design ready. But a lot of things is also onto the RWAs, because primary responsibility of ensuring all the compliances, be it through a manual way or be it through a technology solution, would rest on the RWA. So I think to that extent, the RWA has to be aware of all the compliances that they need to put in place before engaging how to deliver it. And at the same time, the value add that the solution provider would bring is to be aware of this when they are offering these solutions to, let's say, a newly formed community or so. So this is what I would just like to submit on the compliance part here.
Yes, just to add to what Vidya just said, we know that all the MCs are basically volunteers from within the residence. So I generally find that either they are not equipped or the tenure is so short that 12 months just run away, and then we are looking at the next team. And I've come across associations where there are no more volunteers left to come forward and take up that responsibility. So that's also a big challenge in terms of how the management committees are abreast with the existing laws and what is supposed to be done and what is not supposed to be done. I'll take that up. Now, Vidya, what are the challenges that you see members of BAF face in following the rules and regulations governing management of apartment complexes? What are the general challenges that you see?
If I can answer this from a perspective of before BAF and after BAF, I think because that has been very significant what I see. From the last 3-4 years that we have seen, I think BAF came into prominence post the STP rally. So we really, the apartments which started getting notices because of new notifications being pushed by the water supply board on starting to penalize all apartments irrespective of their age of construction or the timeline of occupation. They started penalizing all the apartments for not having STP. I think many apartments continued to pay those penalties without really getting to know the details about the application of that. And I think that is where BAF came in. BAF was formed just prior to that when there was a discrimination in water tariffs. So that is when collectively few apartments came together and started questioning that. And when, while that was not significant portion of what you would call the maintenance charges or so, these penalties which came in for STP, those charges were pretty significant for a lot more people to delve deeper into the regulation aspect. till then, I don't think there were any notices either being served to apartments on various counts, or if there were any such things, I think the apartment managing committees, without delving more deeper into it, would just pay off whatever is the amount is, which was a one-time annual or some such thing, and it was easy business as usual post that, without getting into too much detail or spending too much time. But I think post that, there has been a lot of things which have happened in terms of various other departments starting to get up and start penalizing apartments without expecting that there would be any backlash. It is possible that all these things did happen because there was more information. Now that technology has pervaded and invaded into all department and it's working, there is a lot more transparency, or rather a lot more data, I would say, that is available to departments to act on. And unfortunately, this is the data which is, things which have happened 20 years back, 25 years back. Wherein there have been violations right from the beginning of the handover, from the construction stage onwards till now. All those issues also started, they surfaced because of digitization. And possibly this last 3 years, BAF has spent time trying to delve deeper into these issues, understand why are we paying, the notices come, why are we paying 2 lakh, 3 lakh rupees a month extra? Because that is a huge amount of money, contributing to 10, 20, 30% of your maintenance corpuses. So that is when all these questions have started coming in. So I would say that, now the apartment residents are more, the RWA managing committees are more aware. While they functioned in sort of an autopilot without paying too much attention to their bills and details, today they are really delving deeper into all the aspects, and the awareness that has been created is a lot more.
Thank you, Vidya. Mrs. Sudhir,
Yes.
from your experience, and the journey of buying the apartment and fighting for your rights, and also coming to know that the promoter does not follow the laws, and as you said, just follows the industry practices. Do you think the government is ignoring the fact that the on-ground realities and the laws are not in sync?
Yes, I think this is a very vital space. As I understand, I think it's about 25% or more of the Indian industry, the real estate industry. So this business of regulating the space is very important. If you ask me, the Real Estate Regulatory Act has come about with this as a prime reason. That is to regulate the real estate industry. Having said that, now Vidyaji used the term RWA, Residents Welfare Association. Unfortunately, what happens is the promoter, rather than be regulated and come and do things properly, he leaves it to the buyers and their volunteer associations to start what becomes an RWA. And finally, the RWA gets about doing things, in my view, in an informal manner. There is a need, as per the laws that exist, that this associations that must get created, to whom the transfer must take place of the common area especially, have to be a body corporate. It must be a juristic person. It must be a legal entity. If it is not, then a lot of all these laws and the efforts of these volunteers are actually coming to naught. I would even ask MyGate, for example, when they get into a contract with, say, an RWA, where, say, MyGate is deployed, the question that comes up is your contract with an individual, or is it with a legal entity, which is the association? If you ask me, in most cases, at least in Bangalore, if not in Maharashtra, the answer has not been given. But in law, the answers are very clear, and it's also spelled out in the Karnataka Ownership Flats Act. The body corporate that must get created is invariably, as it stands for the existing laws, either a cooperative society or a company. And unless, and in the state of Maharashtra, in the state of Gujarat, after RERA has come into force, it is now mandatory that associations register under these two laws. So unless you do and get into some kind of a proper legal framework, talk about enforcement, talk about doing the right thing, being immune to, say, actions by the government, it all remains very nebulous. So on one side, you have the government not enforcing it. And second, I would submit, The RWA themselves are very happy with a very informal set of rules. If you talk about environmental laws, which are now enforced and is being enforced in a great manner, RWA themselves are complicit in accepting degraded environment norms for which there are stringent punishments laid down. Say whether it's a lake discharge or not reporting an inadvertent discharge from your STP, or even a fire incident. If there's a fire incident in your apartment complex, you are by law required to report it to the fire department. So these are the kind of areas where I think we need a body corporate, because then individuals who form the office bearers are not themselves held culpable, but there's an association that who can be asked questions and who must answer under the laws. This is the way I look at it.
So just to
add,
yeah, please, Vidya.
Yeah, sorry. So just to add to that, while RERA talks about, registering according to the Societies Act, Cooperative Society Act or Companies Act, we all have gone through this before, so we know
just to correct you, Vidya.
Yeah.
The RERA says that in accordance with the applicable law.
Yeah,
so
so from that perspective, even the Apartment Ownership Act, what we found is, that is what many associations are also registered as under that act. And the act itself talks about, deemed conveyance. That is just to point out when you talked about the conveyance in the new act. And the second thing is also, it has defined, the bylaws and all are defined as per a set of model bylaws provided by the Karnataka Apartment Ownership Act rules, right? So also when you say that, yes, I agree with you completely, Mr. Pillai, when you say that when the handover has happened, all these things have been framed, and if you look at many of these bylaws, they are basically the same model bylaw and just some blanks have been filled. But over a period of time, there have been amendments, because it is a decentralized act and a decentralized way of functioning. So it is through the general body process where you amend within the framework of the law. Now that part is something which we can say is missing right now, because the apartment voluntary committees are perhaps not going beyond what is there in the bylaw and trying to factor in the other laws, or bringing in awareness on that particular front. So what we see missing, while it talks in general about assets and utilities and all those things, it does not go very specific on the various compliances that one needs to follow. So I think it is time for the associations to look beyond now. What changes RERA has brought versus what the associations which already exist, right? They have to function, because there is nobody else who is otherwise going to take care of your functioning of these of your community.
Vidyaji, if I can ask you a question, while I fully agree with you, would you agree that these associations who function in a certain manner have to comply with the laws that exist?
Yes.
Okay, if that be the case, I would submit that it may be worth the while for all existing associations to not just look at KOA as an act. They need to look at these regulatory acts, yes, where the developer was involved, where a transfer was required to be done, where land property rights, etc., common area issues are needed to be sorted out. So unless you do all this, you cannot be doing your job. I'll give you an example of lifts. Each of you, as a member of a management committee, are looking at lifts in a high-rise building. Now, there's an act which applies to the maintenance of lift. One of the requirements of the maintenance of lift is the lift must be licensed.
Right.
How many RWAs have ensured that the lifts are licensed as per the laws? So when an accident takes place, who is responsible? Who's accountable? That is eluding our RWAs. And therefore, I would submit a correct understanding of the laws in a wholesome manner, not just by looking at the KOA, is necessary. And Mr. Sohail Ahmed I would actually put across to him as to where is the link between RERA, KOA, and the KO and COFA. It's the link that needs to be bridged. You can't just look at it on one side and say we are doing our bit. That is, I think, the core of the issue in Bangalore and in Karnataka.
Just to add, just specific to the lifts, I would like to just add a point here. This is a question which was also put across to the industry body, and which came, which counteracted me by asking, is it really true? Once a building has been given an occupancy certificate, which has the NOC right from the electrical inspectorate, who is the authority so far as this is concerned, and all other various NOC bodies, then the occupation certificate itself is more than enough to say all these equipments have been checked, and all the documents have been verified. So you have to make life easier for the apartment association, because you cannot go back 20 years, let's say, for existing buildings to produce documents. If not, then we, of course, these issues we are facing, and we are in fact next week meeting the energy secretary department also, to put forth all these questions and seek answers to all these things. What is the department doing? Because now they have digitized, they must be having records of all these, because there was no guidance provided when the associations were formed, and no documents were handed again at those stages, which would keep records of all these installations individually, because this is just one asset. This is just one lift. There are multiple lifts. There are DG sets. There are various other STP and equipment. So none of those details are available. So what is it that the department can do now that you have digitized and you have raked up all the records? How will you support the associations and help them be compliant? Because as per the lift tax, the associations, BAF has taken a lead in creating this awareness and ensuring that the lifts are maintained. There are laws which state who should maintain it. It's not any run of a fly-by-night operator. It has to be a enlisted vendor. It has to be the AMC. Even the AMC duration minimum, once in 3 months, the lift should be undergoing preventive maintenance. So there are all these various compliances for just one particular aspect of maintaining your asset. So these are the things which we have started to question, and these are the things I think we should look at it also. What is your occupation certificate finally? What does it say? Is it a document which says that yes, everything is compliant, or it has a byline there which says that it is revocable and it is subject to all NOC conditions being met, wherein it should be issued after those conditions are already met?
Okay, so just to answer what Vidya said, the occupancy certificate merely states that the civil work has been in accordance with the building plan that has been sanctioned by either a municipal authority or a town planning authority. However, yes, the existing municipal bylaws require that the fire NOC be annexed with the application that is made for grant of occupancy certificate. It doesn't mean that everything else is in order, because there are occupancy certificates issued without there being a certificate issued by the lift inspectorate for the lifts, and so on and so forth. So of course, merely getting an NOC does not mean everything is in order. So that's something that, of course, yes, there is a gap between the various statutes. Like Mr. Sudhir asked me whether there is a gap. Yes, there is a gap. How do we bridge that gap, and how do we adhere to these laws? Because there are certain differences between what Real Estate Regulatory Act says, what KOA says, what COFA says. Perhaps I think there must be a movement or some sort of a legal process or legal procedure. Somebody should take this up and ask the government to put these things together so that it becomes easier. Because this confusion is also used by the promoters to just dump something on the home buyers, because the home buyers themselves, when the first handover happens, really they are not aware as to what they are taking over. So whether they should understand that thereafter they become responsible and answerable to everything. So that culpability is always there, that when the handover happens, what you take over And what you start operating, you don't know really. These at least the first committee members don't know. They're just people who come together and say that, okay, we'll become the office bearers, but they don't understand. In this line, I would like to ask Mr. Ravi, firstly, do you engage with experts on the subject to address these issues with people who take your software? And are there specific modules that you have created or you are likely to create to make this process of handover seamless and other things, compliance much better?
Sure. So Suelji, so I think what you ask is what we are doing with the product so that the handover or at least transition from one RWA to another and builder to RWA and RWA1 to RWA2 happens. And the second is how do we help our clients when they are in need of help or something, where they need knowledge, right? So the first part, which is like our ERP suite, it has 5 modules, and one of the module is documents, right? So as Vidyaji was saying, like there is if there is a lift has to be licensed, then where that document is kept. If it is in paper, then well, let's say the paper was with builder, it is perhaps lying in builder's office or maybe in somewhere in the society. What we have done is that that paper obviously either can be scanned or can be photographed and uploaded in this document section, right? And you can choose whether to share it with the management committee or you can choose to share it with the overall all residents. And even there also you can choose with whom you can share. You can share it with the owners or tenants or all residents, right? So this module ensures that there is a continuity maintained when RWA1, when builder goes out and first RWA comes in and then the elections happen. So this document will be available to everybody as for the length of the time, okay? Now the second part is how do we help our clients when they are in need? So obviously the need can come, has a different degrees of intensity. So like so the basic ones are whether they can do or something or not, and if they can, then how it can be done. So as I mentioned before, we if we have the knowledge in house, we obviously help them out with that. If we don't have, and if it's a more tricky, intricate, nuanced subject, then we link them up with subject matter experts. Then comes the cases where the help sort is actually quite intricate and involved, and in these cases we have to go above and beyond. I will not go into the details of those cases, but like there is some dispute happening between residents and MC members or inside MC members, we can help them there. And we have built a thing called audit logs, which track what different people are doing. So like which tracks who did what and when. So that brings a lot of transparency, not only for residents, but also inside MC members. So like if there is a 2000 unit society, the MC itself is of roughly 20 people. So they want to track, so like if 4 people are managing the business of treasury, then who is changing what, right? That has to be, that this feature builds a lot of transparency and reduces a lot of disputes upfront.
Okay, thank you, Mr. Ravi. Now, Vidya, we know that the MCs change every year. And of course, when we see other societies, or if you take larger societies, they generally have a person called as an administrator who remains as an employee and who's there throughout, who's able to guide the incoming MCs as to what are the procedures, practices. So he's sort of a person who holds everything together. So is there something that BAF is doing to be able to train these MC members and have some sort of guidelines to have a single person as an administrator so that the continuity is maintained and that there is nothing goes missing from the transition from one MC to the other? Is there any proposal to train these MC members or at least guide them as to what is to be done and how it is to be done, the takeover process, what are the documents that they take over? Because the previous MC may not have maintained things in a proper manner. So when they take over, they kind of walk into a gray area or into a blind spot, not knowing what they are taking over. Are you doing something about this?
What you're talking about, Suhail, is very valid. I think, and also I will take from what Mr. Pillai has said earlier on, not being professionally managed. What happens is, I have seen last 6 years when I joined our MC as well, I could see that to get any information, you have to really, there is no information which is forthcoming. If there is a bore well, then you want to, review and analyze what is the status, what is the depth, where, how do we, how long have they been functioning, what is the problem, and does this need any improvement, recharging, and things like that. There are people who are aware of this information, but they are no longer in the committees, and if you find them, they are not very willing to talk about it, or they may have forgotten, and there is no documentation which is maintained, right? So it is any new member who comes, I think these things have been possibly taken for granted, because there has been no need for compliance or a documentation, to be left behind. There has been no such requirement felt. And also the fact that many associations, while we are registered under particular acts or so, there is really nobody who is, where you are filing any compliance per se of all these various things. So these things are possibly, taken for granted. So there is always a challenge so far as information flow goes from one committee to another. And this is where I feel that a systems approach, for example, if solution providers like MyGate or any other, if they understand all these aspects better, they can add a lot of value in terms of these are way assets, and they need to be there are specifications, there are various associated documents, there are various associated compliances that you have followed. For example, borewell, you also need BBMP permissions to dig borewells, right? So the permission letters for all these things. So there has to be a system which needs to track this. While the, as you said, the constant factor is this administrator or the facility, third party facility management service provider, let's say, they are in charge. End of the day, what we realize is, be it corporate or be it, there is there is an ownership to that. And here the managing committee, which represent, they are the owners of that apartment complex, right? So they are, while the execution can be done by these managers, the ownership of policy making or other aspects does rest with this committee. And there itself, and the manager, if you see, it is not fully professionally managed. I mean, the managing committee keeps changing, and this manager obviously is taking advantage and making his position very firm by being very selective about transmitting that information, knowing the sort of politics or the other aspects that come into play in the managing committee. I think we are all very much aware that there are obviously interpersonal issues when it comes to managing committees and so on. So while the only thing is, through BAF, what we are trying to create is this kind of an awareness that if this policy making body, which you call it as managing committee or the board of managers, if they are aware of various aspects of the running of their association, and we can help provide them that guidance, then there is make it easy for them to manage at the policy level their the functioning of the apartment. Then possibly all those other things will fall in place. So by one we are taking these various compliances, and through our various knowledge papers, through our cluster meetings and various other platforms, we try to bring in this awareness to these managing committees. And once this, I think when it becomes easy that they know there is, if I'm stuck somewhere, if I need information about certain aspect of managing or where I need to make a certain policy, if then I have somebody to go to who will provide me a direction or a guidance, then it is easier for me to look after my perform my function as a managing committee. To take it further, and I will throw this question open to yourself, Mr. Pillai, and experiences of Ravi across societies. I have many associations who have come to me saying that Vidya, there is nobody who is wants to take up the role of an MC. So what do I do? Can I go back to the registrar? Can we ask government to intervene and manage our societies? So, my answer, of course, has been if you want your roads, you have a gated community. If your roads and everything can be as look and see like feel like as all the other public roads, then possibly you can think of approaching the regulators. Yes, but end of the day, we are supposed to function in a decentralized way with a certain with guidance and with certain regulations in place which make it easier for us to run our associations. So that question is still what is the right answer to that question? If I do not have managing committee members or owners coming forward to take this, even be at the policy level, we can appoint for execution third party facility management service providers. But if I do not have this think tank which says I stay here and this is how all our people want this, owners wants this apartment complex to be run like, be it compliances, it's non-negotiable, you have to run it as per the law. But if there are any additional incremental changes that you want to make your quality of life better within the apartment, then without this think tank or board of managers, how do I address that?
Can I suggest how to address it?
Please, Mr. Sudhir.
Yeah, we speak about a protocol that you want to guide you, and let me submit that the protocol exists, and it's a question of whether you follow those protocols or not. The manner in which you put it is the informality by which RWS run. For example, you make a statement that the policy making body is the association. I would submit that the policy making body is the general body who elect an association as office bearers to run that policy that they have voted. It's not because I say it, it's because the law says so. And therefore, it's extremely important that people who take up the jobs as RWS, especially for their own good, because they do an honest day's job, they're volunteers, they spend time. I fully empathize with them. But the problem is the informality of approach that they so easily take up when laws exist on a subject. If today there is a system which says that this is the bylaw, these are the registered bylaws, it is for the management committee to comply with those bylaws unless amended through due process and as allowed by law. But the problem today is in finding that solution, we throw all these bylaws into the wind and then are struggling. What is the end result? The end result is been spelled out by the registrar in his letter of 30th November, when he actually said that associations under KSRA 60, the societies cannot carry out maintenance management. Why? Because in that letter itself, he spells out, because responsibility and accountability can't be fixed. Now you'll say, why should volunteers be made responsible and accountable? That is why your association must be a body corporate, so that the responsibility and association is in the juristic body, not on individual office bearers who do an honest day's job. What happens in the process is, if it's a juristic body that you manage, then you have to have a set of laws to manage it with. You breach that law willingly, yes, you are culpable. So unless this kind of a system comes into place, we are increasingly getting into difficult space. Today in Bangalore, as I said, if I look at my own apartment complex, 2,000 units, 36 acres, there are 17 high-rise buildings with an average of about 20 to 21 floors. And these are all potential fire kegs. If fire starts, if flooding happens, if the STP malfunctions. Professional management is not something you and me want or demand. The law requires it. As a matter of fact, when the 97th Amendment to the Constitution took place, they made formation of cooperative societies a fundamental right. Also, in the Constitution, there are a set of directive principles which have been inserted, which lays down professional management as a core issue. Rather than amateurs get together, put their time together and try and manage what are actually mini townships, I think we need to get this sorted out. Our townships will become bigger and bigger. There'll be, like if you just look at my own apartment complex, the DOD itself specifies that it is a mini township. You cannot run it with an informality of approach. There have to be laws that have to be followed, and the laws do exist. And the laws are not rocket science. They're very simple, clear, very, very doable, provided the management committee opens up the law book, understands the laws and follows it. KOA, let me tell you, is a law which actually serves apartment complexes where the land is on lease. Moment you talk about freehold land, like is the case in most apartment complexes which have been sold as UDS or whatever, KOA doesn't provide you answers. So in my view, the law which exists, which Mr. Sohail correctly brought out, how RERA talks about the existing laws. If you ask me, in Karnataka, that existing law which exists is KOA, and is Karnataka Ownership Flats Act, which lays down that the developer must form either a cooperative society or a company. There's no third option in that. So this business of, some people coming together, setting up associations of their own kind, and then not wanting to take up responsibility, accountability is, I think, the bane of Bangalore. As Bangalore becomes higher and higher, it's a matter of time we'll have 50-story, 100-story buildings in a very small area. If we don't manage this properly, let me tell you, we got problems ahead of us.
Okay, so of course, this is a very contentious subject by itself, because I know historically the way the promoters handed over
Trackbot
the
enables you
apartment communities to the home buyers. Some of them chose to register under the Societies Registration Act, and some of them are continuing to perform through the bylaws. And of course, there are far and few who are registered under the Cooperative Societies Act. Now, I think it is with the government to address this issue, to make sure that how do we come onto a single platform so that these ambiguities, these confusions are not there. Perhaps I think there has to be some sort of a movement. I think BAF also could take play an active role in this, to bring this to the attention of the government, that these things need to become uniform, so that this confusion is not there with the home buyers, and then the promoters don't take advantage of this, because most often than not, the promoters take advantage. In fact, though I do practice in a complex where I'm buying an apartment, the promoters is acting in such a high-handed manner that we are not able to get any answers. So we are forced to take things up legally, which more often than not, we see that it takes a long time, and it takes years together for that to be resolved. By that time, then you are forced to take over the maintenance, and then the maintenance charges start. So there are so many factors that affect, and then you are kind of forced to ignore certain things and then move forward. So perhaps that is what is happening with most of the RWAs, which is why they're continuing to function in whatever manner they can be. Of course, like Vidya pointed out, that you can't stop it. So because you can't stop it, then you take up something and then perhaps start practicing, start following something which is not right. Now, I would like to ask Mr. Ravi, is there something that by way of FAQs or guidelines that you put up on MyGate? And how often do you update this? And do you actually take expert opinions while doing this, or are you doing this out of your sort of whatever you've come across as a problem? Do you actually take the help of experts in each state to make sure that these are compliant with the relevant statutes?
Oh yeah. So Suelji, it's a very relevant point. So the way this thing works is, we get problems from our residents or RWAs, right? And they just want the solution to the problem, right? As Pillai sir said, like whether it is being compliant or not, that's the secondary or afterthought. First, let's solve the problem, right? And there it becomes very, very important for any solution provider. And MyGate is a solution provider that we actually build our solution compliant with laws, right? So one of the things that I'll give you an example at the end of this thing, that we actually consult a lot of experts on the legal side, in the accounting side, as well as on the privacy side, when we are building a solution. Because uh, building a solution just on the vacuum without taking different stakeholders into account is bound to fall. And one of the stakeholders are obviously the regulations, right? So one pertinent example I can give you from the top of my head is that once an invoice is created, it is an immutable document which cannot be changed, right? A legal document. But we have heard back from these RWS that they issued a wrong invoice and they want to change it, right? And since we consulted multiple experts in this area, multiple CAs who deal in the society accounting, we were on a firm ground that this cannot be done. The right approach is to basically cancel the invoice and reissue another invoice, or issue a credit note or debit note. Right? So there are ways this issue can be handled, but it is definitely not the way they are thinking. Like, let's scratch it out, write something else on top of it. It doesn't work like that. So obviously, what you are actually saying is that it behooves upon us to consult experts, and not just once, but multiple. And we actually do. So like recently, we became compliant with GDPR, General Data Protection Regulation. And there also we consulted several experts to be compliant with this. So obviously, we do take a lot of care when we are building these solutions.
So do you actually have any FAQs and guidelines, and how often do you update this?
So we have FAQs and we have guidelines, and we have started rolling out best practices as well. And the FAQs are almost, they are updated almost on a monthly basis, right? And we are basically bringing a lot of automation so that we know how old the queries are. And we are actually building a funnel to these FAQs so that they are, so let's say that we build a questionnaire of FAQ of, let's say, 1,000 questions. We currently have that much. And new questions are coming, then we can keep feeding into them so that the inventory is fairly new rather than a stale one.
Okay, thank you so much. I think we are almost at the end of our time. There are a couple of questions, if I can take them. The first question is, can BAF help out with compliances for apartments to follow by constituting a panel of experts who apartment can consult? Vidya, this will be your question to answer.
Yeah. I think those who are already BAF members, they are aware. While we have, this year started, creating a center of excellence kind of body. We are trying to put together, but informally, there are members who know that if they have specific problems, whom they need to reach out to within BAF. And secondly, those who are non-members, they do write to us on our email IDs and other social media platforms as well, and they reach out to us. So what within the knowledge that we have and the best practices and experiences that we have accumulated across our member database, we do share that knowledge information and provide them the support. If it is over and beyond what it is, or it is, as we all know, there are certain, there is not too much clarity in various laws and its implementation. If there are any of such issues, then I think Suhail and Mr. Pillai, you must be aware that we do take your assistance as and when we come across those issues. So yes, we have started, because see, last 3 years we have been sort of on a firefighting mode, right? I mean, our apartments have been issued notices without following any due procedures, or leave alone notices. It is, as we speak, we had somebody who called last night to say that there is a board authority which has come to disconnect certain, water supply connection without following due process. So what should I do? 4 officials are here. I said, have they, given you any notice? Have they asked you for any show cause? Have they asked you for any explanations? No. So this is from the pollution control board, from the water supply board, from the solid waste management side. So there is, a continuous stream of such issues which are coming up, and which we are trying to go deeper and understand and provide support to our members. Parallelly, we have also put for the KOA and for all these other association related issues, creating awareness, providing them direction or guidance. So all these things we have put in place. So I would suggest that, one is to become a BAF member, so that you are aware more and more about all these compliances, so that you can raise beyond that, and it can be a part of your bylaws. You know what you are getting into when you're, even the initial committees are being formed. So while through the till last year, where we had already existing, managing committees or apartments who were becoming BAF members, through last 1.5 years, we have seen that many apartments which are in the process of taking over from the developer, they are also coming forward, and their ad hoc committees, they are spending from their own, collective corpuses to ensure that they become BAF member, and they can they can have access to all the knowledge base that we have created through, which is of course available through the portal also. So it is a constant endeavor. I mean, we have not gone even 50% of what all things are possible to be done, but there are a lot of things that we are looking forward to, and I'm sure with the help of all your views and inputs, we will, go from strength to strength and be able to support the apartment community in Bangalore.
Can I make a small suggestion to BAF with your permission, Mr. Soil?
Yes, please.
Yeah, I would submit to BAF that they have no choice but to be compliant with the law. So therefore, the first thing BAF needs to do is use your collective strengths to get people like Mr. Sohail Ahmed and so many others who have a very detailed and good understanding of the laws. They are professional lawyers as to what is the law, where do we stand. That will open up a window of understanding, which today I find most association, and permit me saying so, even BAF wants to sidestep. They look at the legacy of the past as a crutch. You need to look ahead. You need to look for the future. A lot of your old buildings will slowly get redeveloped. The city, which will soon host 50% of the rural population, is headed in. If you don't sort these out today and get compliant, let me tell you, Bangalore will not be a place to live in. I would like to make a small submission. We had a beautiful talk the other day in the Bangalore International Center by a lady who spoke on the uncivil city. Right? We are ending up as an uncivil city. In that talk, she spoke about how in Ashok Nagar in Delhi, a very affluent complex, the residents got together and beat up a local and killed him because he was going to do his natural routines when there are no toilets provided. So I think we need to think about all this. We stay around area, we got swimming pools, we got all kinds of things in our complexes, but we have to take everyone along, and for that, the law and its enforcement is most essential. Otherwise, we are in for hard times. So my submission to BF, get compliant. At the moment, you're not compliant. 80% of your associations are not compliant. Get compliant.
Okay. So
yes, sir. That's the process we are on. I think the first step to do is create awareness, create engagement, create involvement, and all these things will start coming together.
Just to add to that, Vidya, can I suggest BAF has a sort of a task force which is there as a permanent body to assist all these RWAs, wherein these day-to-day problems can this task force of maybe permanent employees who are experienced in all these laws and be able to answer these questions, they are able to assist these RWAs. Like you said, somebody suddenly drops in, like somebody from BESCOM comes suddenly and says, we want to disconnect the power. So if they are available either uh, immediately to answer these questions or pose questions to these officials, to, to help them tide over these day-to-day difficulties, I think it will make a lot of sense to have a sort of a task force where you have permanent employees, maybe a set of 3 or 5 or 6 employees, where they actually have an office, so that these things could be addressed much more easily. And also they, like somebody's asking, can we have an expert? Where do we go and ask and these questions? Of course, people like you are always available, but I'm sure you are also professionally involved. So if you have a separate task force just for this, and you know that these people will be able to answer within the framework of law, I think it should help. The next couple of questions is, of course, the positive suggestions: which law RWA has to follow if there is a conflict, what rules are to be formed, even if it is at a government level. Um, uh, Perhaps to answer this would be the most difficult thing currently, because we know, as Mr. Sudhir also said, that many complexes are non-compliant. While we say so, the ground realities also have to kept in mind. I'm sure BAF also faces this. It's a question that they are neither able to answer or neither are able to give a solution to. Because yes, of course, one thing is, as what is the legacy issue which Mr. Sudhir also spoke of. We are carrying forward a legacy which through the lack of implementation on the part of the government, I would say, because had the government implemented these laws strictly and given some teeth to these laws, then the promoters would not have dared to violate these laws. So since that has been done, and even to this day, while RERA has come in place, the promoters, even some of the large corporates, are also wanting or willingly and I would say deliberately, they are willing to violate these laws as though they are above law. So I myself have seen this, and I'm sure Mr. Sudhir is also has. I would say he's here because of such an issue that he personally faced. Otherwise, he would have been happy in his life and going about his things. So, because of such issues, he's forced to take up this, and of course, he spent his valuable time trying to learn what is relevant, what should be done. So it's a difficult question to answer as to what positive suggestions to make, but of course, this responsibility would rest with the government, and hopefully with RERA come into place, now we are 3 years into RERA, these questions are being asked, as Mr. Sudhir said. I'm also aware that RERA is asking these questions to the government, and constant representations are going. I think in the shortly also a specific question will go to the government as to what needs to be done. So perhaps we need to push the government either through the administrative process or taking it up judicially, so that we force the government to answer these questions, so that we are not in the gray area. And a method of transition also has to put in place, because we know many associations are formed under Societies Registration Act. It's like we don't know after 30th 11 2018, of course there are no associations which can be registered under the Societies Registration Act, but there's no clarity as to what happens to those associations which have already been formed. So they're always, it's like a hanging sword. You don't know when the societies registrar will simply land up there and say that you are defunct and you have to stop functioning. So that being said, of course, the entire ecosystem has to put in place. I always say, though RERA is there, the allied laws are not in place, not just for the allottees, but also for the promoters. It's like the things are not in sync. So until everything falls in sync, then everybody will be able to follow and will be able to abide by the laws. So that being said, I think we still, even I being a legal professional, though I'm aware of all the laws, we won't be able to make a positive suggestion other than to make sure that yes, you ask of a promoter what is the right thing to do. We'll allow the promoter to try to implement that. While doing so, they may approach the relevant authorities or the courts to make sure perhaps we'll get some answers there. Now, the next thing is POFA and KOA need to be amended. Of course, that goes without saying that it needs to be amended. And Mr. Sudhir, I think there is a question: cooperative society or a Section 8 company? Can you just throw some light with your experience there?
Yes, what I would submit is where the promoter was required to do certain things, and when he doesn't do it, and when the association takes over, what willy-nilly is happening is the responsibility and accountability which the promoter had at a certain stage is just being passed on to our, volunteers. So therefore, we need to get this whole ecosystem ordered correctly in line with the laws. If the laws are followed, let me tell you, the association will be so much happier. So why? What is the association that must get formed? Like I said, in Maharashtra, Gujarat, it's already been specified. The rules, the RERA rules there now specify that you have to register either as a cooperative society or as a company only, nothing else. Why? Because these two laws create a body corporate, the juristic person. And the moment you create a juristic person, the association gets a status of its own, gets a common seal, gets perpetuity. Even if the association members keep changing left, right, and center, like we were discussing with this gentleman from MyGate, it doesn't affect the body as such stays. You can sue, you can be sued. Contracts you can enter into as an association. Today, all these are very gray areas in the system we follow. It was okay for small little apartment complex where you developed your, 10,000 square foot plot into a 4-story building and started living together. Not anymore. Can you imagine 17 blocks, many row houses, 3 swimming pools, 23 floors each, thousands of cars to be parked, water to be provided, sewage treatment to be done internally, garbage to be disposed of internally. It can no longer function. What should erstwhile associations do? If you ask me, you take your first step and encourage associations to slowly register as a cooperative society. It has already started happening in the state of Karnataka. Cooperative housing society registrations have started. A lot of people have the doubt that if you go that way, you will end up losing your ownership. I beg to differ. If you look at the Maharashtra rules, there is a form of cooperative society where you will continue to be owners of your apartments, where the common areas are held on your behalf by the cooperative society. It will permit everything. It will permit professional management. It will permit proper accounting of your funds. Everything, all your woes, which you today try and tackle through an informal method, which is increasingly getting contested by many residents, it'll all sort itself out. So what should you register as? Start as slow but sure migration as required by the law. Not something I am saying you must do. The law actually in Karnataka requires you to be either a cooperative society or a company. If you want to form an association under Apartment Owners Act, at least ensure that your common areas are conveyed in the name of a cooperative society. This is what I would submit.
Okay, just to add to what Mr. Sudhir said, of course, the difference between the Karnataka Apartment Ownership Act and RERA is earlier, of course, the undivided share, a percentage of undivided share was required to be conveyed in favor of an allotee. However, RERA requires that the entire land should be transferred to the association. Perhaps the uniformity has to come into play. And of course, while we transition into a cooperative society, how these things are to be addressed would be through a statute, and it is easier said than done that, yes, we move over to the cooperative society. Of course, this fear as to who will own the land and how will, of course, like we know that we are staring at redevelopments, how these things are going to be done. Because undivided share that has been conveyed, if you put the whole of it together, may not constitute the entire land in the older complexes. So there are many questions that need to be answered. Perhaps we'll come to that. So I think we have no more questions. I would like to take this opportunity to thank BAF for having me here, and of course, all of us here together. I hope that we have done justice to this topic. Thank you, Mr. Ravi. Thank you, Mr. Sudhir Pillai, for taking time out. And of course, Vidya, of course, she's always there with BAF. Thank you so
Yes.
much.